you all very much for coming here this morning to learn a little bit more about estates and taxes and so forth. We're delighted to have as our guests two fairly local attorneys, both with the firm of Tumu Latham in Riverhead. And I'd like to introduce them to you. First, Laura Jonathan is a partner of the firm in the estate planning department. The primary areas of practice are estate planning, estate and trust administration, elder law, taxation, and the representation of nonprofit organizations. Her personalized service and her attention to individual circumstances is a hallmark of her practice. She holds a Bachelor of Science from St. Joseph's, earned a Juris Doctorate from St. John's University School of Law. She's a member of the Suffolk County and New York State Bar Associations. She is especially passionate about representing the elderly and individuals with special needs, and has successfully represented clients before the U.S. Tax Court, litigated matters in Suffolk County Surrogates Court, and prepared ruling requests from the IRS. She is thoroughly knowledgeable in gift, estate, and generation skipping tax matters. She's also a former co-chair of the Suffolk County Bar Association's Taxation Committee, and has served for several years as a volunteer for Literacy Volunteers of America. She's an active Rotarian and a member of the local Chamber of Commerce. And she resides in East Mauritius with her husband and 3 children. So thank you, Laura, for being here today. And her partner here today is Anne-Marie Goodell. Anne-Marie has personally assisted clients to establish estate plans that suit their needs, including the creation of trust agreements, wills, living wills, powers of attorney, and health care proxies. While her practice is primarily focused on estate planning, trust, and estate administration, elder law, and taxation, she is also experienced in the areas of business succession planning, charitable giving, and real estate transactions. She has lectured on the subject of estates and trusts and long-term care planning, and is responsible for conducting many in-house seminars on estate planning. Ms. Goodell received her Juris Doctorate degree, cum laude, from St. John's University School of Law, and a Bachelor of Arts from Lemoyne College. While at the university, she served as a notes and comments editor for the St. John's Journal of Legal Commentary, in addition to having a note published in the journal. She currently lives in Aquabog with her husband and 4 children. Please welcome Anne-Marie Goodell and Laura.
Thank you for having us here today. We're very excited to be here. We have a great turnout. As you can see, we'll be talking about estate and tax planning with trusts and the importance of using trusts in this context. So what are the people's goals when they do estate planning? One of the goals is minimize the expenses of probate or administration. So New York State has a law that requires notice going out to closest family members when a will is being probated. Many times people use trust to avoid the expense and the delay in probate, and we'll go into that a little more. Another goal is appointing guardians for minor children. This is important since you choose who you want to name as a guardian for your minor children. Otherwise, family members oftentimes may fight over who will be in that position. So by putting this into your will, it's very important that your desire is effectuated. Appointing trustees to manage assets of beneficiaries is also very important. Planning for special needs of beneficiaries or of the elderly. This is important since any inheritance that you may leave to someone could impact any government benefits that they will receive. Orderly disposition of wealth to individuals and entities as desired. So again, your desires are being expressed through these documents, and it's important that that gets put into the documents, otherwise some unintended consequence could happen. Planning for incapacity and long-term care, and we're going to get into that in detail. Minimize estate gift, income and generation, skipping transfer tax. Again, we'll be going into detail on this. And fulfilling charitable goals.
So then we have a basic estate planning documents, which many of you are probably familiar with already. Last will and testament, healthcare policy, living will, I'm sorry, I didn't put the screen there, living will and adorable power of attorney. Without a last will and testament, the law provides how your assets are to pass. So if you don't know the law or are not familiar with it, it's going to be your closest relatives. It's first down to your spouse and children, and then just children if you don't have a spouse. And then it starts going further, it goes to your siblings, and then, well, parents first, I'm sorry, I forgot about parents. But anyway, so your wishes are of utmost importance. So that's the purpose of the last will and testament. I don't want to go through all of the details here, but one thing that I do want to point out is the last line here, assets not controlled by will. What a lot of people forget about is, all right, so now they have their will and it says who they want their assets to go to. But what they don't realize or pay attention to is that they may have a lot of assets that aren't controlled by their will, such as retirement benefits, insurance. Most of these pass by designated beneficiary. Or if you have savings accounts or investment accounts with a joint owner on there, those assets pass directly to the joint owner. So your will does not control who these assets pass to. So it's very important to pay attention to the whole picture and make sure that your wishes are incorporated into everything that you have.
Basic estate planning documents, healthcare proxy. A healthcare proxy is very important because you're appointing an agent to make healthcare decisions for you. It could be routine decisions, so very basic if you're incapacitated, but the doctor needs to speak to someone on your behalf regarding routine care, to end-of-life decisions. So do you want to be have tube feeding done? Do you want artificial nutrition and hydration, mechanical respiration? So again, the healthcare proxy is where you appoint the agent to make those decisions for you. A living will is another important document to have. It really expresses your wishes regarding life-sustaining measures. So if you're in an irreversible condition, no chance of recovery, it will say what you would and would not want done. So it's giving guidance to your agent as to what you would do in that situation. Then the final document that's extremely important to have is a durable power of attorney. What durable means is that it survives incapacity. So you want to execute this document while you obviously have capacity to do that, and then if you become incapacitated, an agent can make legal and financial decisions for you. So essentially, that agent is stepping into your shoes, can access your financial accounts, can make decisions, help with bookkeeping, paying your bills, things like that. Another important aspect of the power of attorney is giving your agent gift-giving ability. Now, that concept is a scary concept because you're saying, okay, my agent can transfer assets out of my name. But it is important to have that ability because without that, if you need to do estate tax planning, transferring assets out of your name to reduce your estate and save estate taxes to your beneficiaries, or for long-term care planning purposes where you need to shift assets out of your name, without having that power in the power of attorney, the agent is very limited with what they can do. That being said, because it is such a powerful document, the person that you name as agent, you really have to have complete trust in because they can handle all your affairs and access your accounts. So while most times there aren't problems, there can be problems with the agent exceeding their boundaries. What is a trust? So a trust is a legal agreement where a person, typically called the grantor, transfers legal ownership to assets to a trustee who holds the title to that property for the benefit of a beneficiary. So the assets really don't become the trustee's individual assets. They're holding the assets in a fiduciary capacity. So it's not the trustee's individual assets. Their creditors can't reach those assets. They're guided by the terms of the trust agreement as to how to administer the trust and what they can do with those trust assets. The trust, again, it stipulates how the assets should be managed and who they will be distributed to. So routinely, there's someone who's called the lifetime beneficiary or the income beneficiary. That's who has current use of the trust assets, and then usually then at the end, either upon an expiration of a term of years or upon their death, then it would pass to other beneficiaries. Trusts can be flexible because now you can really spell out the terms of what you want done with the trust. Is it for a minor child? Is it for a child that maybe has some financial problems, so we don't want to transfer assets outright to them because that child's creditors can reach the trust assets, or maybe, if there's situations of alcohol or substance abuse that you don't want that child to receive those assets outright, it's preferable to keep those assets in trust and just spell out how they would receive the trust assets. So for example, the trustee could pay for the rent of that child, could pay for other things that they might need. And the trustee has a fiduciary duty to the beneficiaries. What that means is they have a high standard of utmost honesty. They have, again, they're held to a fiduciary duty, and there's no self-interest there. So sometimes in selecting a trustee, there could be a conflict in that the trustee is also a potential beneficiary of the asset at the end as a remainder beneficiary. So you just have to be careful in selecting the trustee, making sure that they will handle the role of trustee properly. Types of trusts. We have living trust or inter vivos trust, and we also have testamentary trust. Living trusts come into existence now. So you create it now by a written agreement that is signed by you along with by the grantor and by the trustees. You then end up transferring assets to fund the trust during your lifetime. A living trust could be revocable, meaning you can revoke it at any time, you can amend it at any time. It can also be irrevocable, which technically it says it's irrevocable. There are ways to revoke an irrevocable trust. New York State law does provide a whole mechanism of how you can amend and revoke an irrevocable trust. But the idea with irrevocable trusts are you're transferring the assets outside of your reach and control for either tax planning purposes or long-term care planning purposes, so that it's no longer yours, so to speak, to do with whatever you want. You now have a trustee that is managing those assets for you. And then there's a testamentary trust, and that's created upon the death of the person. So in their will, the will would then contain a trust and comes into existence only upon the death of the party.
Okay, so why create a trust? A lot of these have very similar purposes as a will. However, one of the important points to note is to ensure the orderly and confidential transfer of your property to your beneficiaries. So as Anne Marie mentioned earlier, when you probate a will, the will has to be deposited with the surrogate's court, and that becomes public record. Anything that happens in the surrogate's court is pretty much public record. If you have a revocable trust or a living trust, and that trust governs where your assets go, that trust is not deposited with the circuit court. So a lot of people like the idea of a revocable trust because there's a lot of confidentiality. Okay, we could use some famous people, for example, that we're surprised did not have a trust. And we can read their wills and look at who benefited. All right. To provide a structured way to administer your personal and financial affairs should you become ill or incapacitated. Now this is important also because if you have a revocable trust, as opposed to just a will, and you actually fund it with assets, so the revocable trust actually owns the assets, you're the trustee. You can be the trustee if you're not looking for tax planning purposes or long-term care planning purposes, which we'll get into. But as soon as you lose the capacity to manage your affairs, the person who you appoint as a successor trustee can step up merely by signing an acceptance of trusteeship and act and start to manage those affairs for you, which is good. As we age, we don't know what's in store for us, so it's important to have that flexibility. So now we don't need court intervention for somebody to manage our affairs. To provide for an elderly relative or child with special needs. Anne-Marie touched on this earlier. If you have a child with special needs or a relative with special needs or anybody who's receiving government benefits, it's very important to protect them and make sure your wishes for that individual can be carried out throughout their life, as opposed to you leaving them assets and their government benefits go away because of their inheritance. All right, so there are ways it's called supplemental needs trust, or also known as a special needs trust, to make sure that those government benefits stay in place for that beneficiary. To minimize the tax consequences of the transfer of your assets now and in the future, so we'll get into that a little bit later, but trusts can be created for many different purposes. Often they're created for tax purposes, to protect your estate from taxes. To protect your assets from creditors' claims. So it's difficult in New York to fund a trust that you create with your own assets to protect them from your creditors. But you can protect your assets from creditors of other beneficiaries. All right, Anne-Marie touched on that earlier as well. To transfer assets that are in many different states. So like a probate in New York, if you only have a will and you own property in New Jersey or Florida or wherever, your will has to be probated here and then it has to be brought down to that state and be probated there. It's called ancillary probate. But if you have the Florida property titled in the name of a trust, you don't have to probate in Florida. The trust governs what happens with those assets on your death. So we avoid an expense and time. All right. Okay. There's a whole page. There's a whole other page. All right. All right, so manage assets for dependent children and other beneficiaries who are unable or not mature enough to manage assets. It's kind of self-explanatory. To protect the interests of your children from a previous marriage. All right, so now this is very important because a lot of us are on second marriages or third, and the law in New York says that you cannot disinherit a spouse. So that means when you pass away, your spouse has the right to inherit at least 1/3 of your assets outright, okay? But if that's not your wish, and you want your assets that you've accumulated during your life to pass to your children, not to your second spouse's children, then you have to take some steps to make sure that happens, okay? And that can be done in your will, and it can also be done in a trust, or through trusts in your will. What you want to do is you want to leave the assets maybe to your spouse so that he can enjoy them for the rest of his life, but then on his death or her death, those assets will be sure to pass to your children. All right. Okay, so to make tax advantage gifts to charity, we'll touch on that a little bit later on. to finance a child's education, self-explanatory, to free yourself from the administrative and record-keeping details of managing your financial affairs. I would assume we get too busy to deal with some of our assets at some point in our lives, and we want to involve our children a little bit more, so we can create a trust and have them be a part and learn, the responsibility of managing assets or businesses. To avoid probate costs and potential delays. Okay, so we kind of went through that already. All right.
The pros and cons of a revocable trust versus a will. So as Laura had touched on, a revocable trust is very useful to avoid the probate costs and delay of probating. So that's a major advantage of the revocable trust, is that automatically upon a person's death, whoever is the successor trustee, they can step in and start administering those assets. There's no need to go to the surrogate's court and file the will for probate and file a probate petition and have someone officially appointed by the court as the executor of the estate. With the revocable trust, as I said, automatically the successor steps in, signs a document accepting their trusteeship, and then they can start administering the trust at that point. Avoiding probate of out-of-state property. So again, Laura had touched on this, that if you own property in other states, those states require an ancillary probate if that asset is in your individual name. If it's in your revocable trust, there is no need to probate in that other jurisdiction. So you're saving the time and expense of probating in that state. Another advantage is providing for the management of assets in the event of disability or incapacity. So again, a revocable trust comes into existence during your lifetime. You can be the trustee of your own trust, but if you end up becoming incapacitated, who then is going to handle your affairs? So while you may have already done a power of attorney, and it is still important to have that power of attorney too, in addition to the use of the trust, but with the trust assets, the successor trustee can step in and start administering the trust assets. And also another important feature of the revocable trust is in the event you leave your assets maybe not equal to all of your children, or you're including some other person as a potential beneficiary, and you're concerned that maybe someone is going to challenge my will, by having your assets in the revocable trust, there's no forum for that person to object to what the trust says. They actually have to institute a proceeding themselves and file an action in that court to say, hey, this trust needs to be set aside because I don't like the terms. I mean, there has to be valid challenges as to why they don't agree with what the trust says. But unlike a will, you have a court proceeding in front of you, and that person can come in and just right away object and want more information on why maybe they're not. Yeah. So with regard to the will, as I said, there is a court proceeding already on file that you're required to give notice to the closest family members of what your will says. And if one of those closest family members is not receiving or is receiving less, they can come into court and object. And then we go through the whole litigation with regard to the will at that point. There's only certain grounds that they can object on. They can't object just because they're receiving less. There has to be valid grounds for that. And then avoiding public disclosure, we already spoke about that. So typically with a revocable trust, how is the trust set up? Usually,
I'm going to put this microphone between the two of you so that because that one is sorry.
Yeah, no, that's
and then you can
okay.
all step up to the so that's
Okay.
All right. So the way a revocable trust is set up, typically the grantor is the trustee. So you would be your own trustee. You're in complete control of the trust assets. You could do anything that you want with those trust assets. You can add assets into the trust, you can take assets out, you can distribute the trust assets as you please. There's no separate tax filing for the trust. It utilizes your Social Security number. So from an income tax standpoint, you'll be taxed just the same as you are now. But the benefit of the trust then is later on, it is a will substitute, meaning those assets will pass to the designated beneficiaries named in the trust. Disadvantages of a revocable trust. The time and expense of retitling assets. So maybe I'll step back. What this means is in order to fund the revocable trust, the assets actually have to be titled to the name of the trust. This entails for real property, having a new deed drawn up in the name of the trust. For financial accounts, it means contacting the financial institutions and having the accounts actually titled with the financial institutions in the name of the trust. The trustee, and then you're signing as trustee all of the paperwork with those financial institutions. The problem of not fully transferring all your assets to the trust is now all of a sudden you have a number of assets in your revocable trust here, but I have some individual assets that now require me to probate. So oftentimes people end up having to also probate their will because they forgot about some asset and did not transfer it to the trust. So you really do want to make sure that if the primary purpose is to avoid probate, that your assets do get transferred to the trust. Other than assets that pass by operation of law to people, what that means is retirement accounts, you do not want to transfer to the trust because that creates a problem, an income tax consequence at that point in time. So you want to have a designated beneficiary with the financial institution on file for the retirement accounts. Revocable trusts, because they're considered your asset, there's no estate or income tax advantage for transferring assets to a revocable trust. There also is no benefit for long-term care planning purposes with a revocable trust. We'll get into irrevocable trust where there is a benefit for both of those.
I just want back and forth. Okay, I just want to make one point here. We're talking about revocable trusts and how useful they are, but not everybody needs a revocable trust. Wills can be fine. Probate in New York is not an arduous process. It's not very expensive. The maximum filing fee is $1,240. So we don't want to scare you into, you got to get a revocable trust, because wills in New York can be fine. So if you don't have any issues with your children, or everybody's inheriting equally, and there's no special needs issues, then you could have a will. It is okay, especially in New York. But revocable trusts have a purpose, and we kind of pointed out quite a few of them. Now, one thing that a revocable trust doesn't do is protect your estate from estate taxes, okay? Because whatever assets are titled in that revocable trust are yours. And they will be included in your taxable estate. Right now, on the federal level, there's two levels of estate tax. So this is not income tax. This is, a separate layer of tax. There are two estate taxes that we have to be concerned with. Federal estate tax. In 2016, an individual can pass $5,450,000 worth of assets tax-free. Okay? So if your estate is below that, then we have to worry about the New York level. In New York, as of April 1st, 2016, you're allowed to pass $4,187,500 tax-free. Gotta get that 500. And that amount is going up. On April 1st of 2017, $5,250,000, and January 2019, the New York estate tax will match the federal estate tax. Okay. Now, the federal estate tax is indexed for inflation. So last year, the amount that an individual could pass tax-free was $5,430,000. And the year before, it was $340,000. So it goes up with inflation in increments of $10,000. Okay? So at some point, New York will match the federal. Here's the kicker. Hillary Clinton is proposing for a federal estate tax credit of only $3,500,000. So again, New York will match that. So $3 million. And Trump's proposal is to do away with the estate tax altogether. I'm not sure if he's going to replace that with a capital gain and income tax regime, which is likely that that's what would happen. But the estate tax rates on the federal level are much higher than the income tax rates for capital gain. All right. The highest estate tax rate is 45%, right? And the highest New York estate tax rate is 16%. Okay. On the federal level, you see there that it says portability. Spouse's unused exemption passes to surviving spouse. So this is important because in addition to the credit, we also have something called an unlimited marital deduction, which means one spouse can leave any amount tax-free to the surviving spouse. Okay? Any amount. 40 million. I die, I leave everything to my husband. I should be so lucky to give him 40 million. So if I die and I leave him the 40 million, I never use my credit. Okay? So my credit never got down to my children because I used the marital deduction. I didn't use the estate tax credit. All right? So on the federal level, they allow my husband to file a return saying, well, wait, my wife didn't use her $5 million. I want her $5 million when I die. So when he dies, $10 million can go down to the kids tax-free. All right? But that doesn't exist on the New York level. There's no portability. And portability is fairly new in federal estate tax law as well. And who knows if it's going to stay around. I would hope so. So on the New York level, there is no portability. Okay? So if I don't use my credit, I lose it. My husband will, my combined estate between my husband and I will never get the benefit of my credit. All right, so I want to give you an example of a trust that can be built in to your estate planning documents, whether that be a revocable trust or a will, that will make sure that my credit is taken, well, our credits will be taken advantage of, so that on the death of both spouses, we will be able to pass the $10 million tax-free even in New York. It's called a credit shelter trust. I'm sheltering the credit of the first spouse to die. Okay, so it's right up there, preserves the estate tax exemption of the decedent spouse. Now the trust can be automatic, or the surviving spouse can decide how to fund that trust. Okay, I can, and in fact this is part, Anne-Marie and I, our standard documents have a credit shelter trust built in there. If you're a married couple and you come to us for planning, you're getting that credit shelter trust whether you want it or not. Because you don't have to use it. It can be funded by the surviving spouse. All right, so it says, if I die, I leave to my spouse all of my assets. However, if my spouse chooses not to take some of my assets, then they go into the credit shelter trust. So we're giving the surviving spouse the benefit of reviewing the estate tax laws at the time of death, reviewing the size of the estate at the time of death, and deciding whether or not it would make sense and save taxes eventually when you leave the assets to the children or wherever they may go, to fund the credit shelter trust. Okay? Okay. So here's what we call an I love you will, or an I love you revocable trust. Honey, I love you, you take everything. Okay? So husband's estate is worth $3 million, wife's estate is worth $3 million. So combined estate is $6 million. Sorry, but I killed off the husband first. So husband's estate passes through his will or his revocable trust and passes, let me see, I don't know if you can follow me, it's kind of all squished in here. Husband's estate, he passes away, he leaves $3 million to his wife through his documents. I love you, honey, take all my money. Okay. All right, so now later, wife dies. She's got her own $3 million, plus the $3 million she inherited from her husband. Okay? So that, on her death, she has a $6 million combined estate. Okay, so if we go back a second here, we see that in New York, you can only pass $5,187,500 tax-free. Or even if we were at this level, or even if we were here. Okay? The estate of the wife, when she passes away, will bear a tax of $500,000. Okay? Unnecessarily. That's a New York estate tax. This is assuming that she elected the portability on the federal level. So we're not worrying about federal tax, but we are worrying about New York estate tax because there is no portability. So I can't say, my husband didn't use his credit, I want to take it. So the children's net, I mean, it's not horrible, they're getting $5,500,000, but $500,000 went to the state unnecessarily. Okay? Here's the example with the credit shelter trust. Same thing. Husband and wife have $6 million. Husband dies first. Husband's $3 million over here passes to the wife, but the wife says, well, wait a second, I don't want everything. I'm gonna disclaim assets, saying I'm not taking these. And that disclaimer actually has to get filed with the surrogate court within 9 months of the first spouse's death. So she disclaims assets, and the will says, well, if my wife disclaims assets, they fall into this credit shelter trust. And here's the credit shelter trust, right here. So wife says, and she has the ability to pick and choose what assets she doesn't want. Anything that she doesn't think she's going to need or touch or use, because she has her own $3 million. So that falls into the credit shelter trust, and this trust benefits her during her life. So if she ever needs assets, she can get them. She cannot be the sole trustee, though. She shouldn't be the sole trustee. We usually put a child on with the surviving spouse, okay? So on the death of the spouse, the trust spells out where the assets go. Usually they're the same as where the wife's assets are going to go, to the kids. So on wife's death, the $1 million she inherited from her husband is here. Her own $3 million is here. That $4 million passes according to her will or revocable trust, right, down to the kids. At the same time, the credit shelter trust pours out, and if she hasn't touched this, it's probably appreciated. And that passes tax-free through husband's credit. Husband's heirs usually the same as the wife's heirs, $2 million, plus this $4 million. $4 million in New York, there's no tax. You get $6 million to your heirs without any tax, making sure you use both spouses' credits. So that's a basic trust that should be incorporated into your document. Okay. Okay. So we have additional estate tax reduction trusts. You may have heard of the $10,000 annual exclusion. That means you can give $10,000 to any individual that you choose in 1 year, any individual. So as many individuals as you choose in 1 year, tax-free without filing a tax return, without filing a gift tax return. Right. That I know. I go back to $10,000 because that's what a lot of people think of, but that amount is $14,000 now. So this year is $14,000, and that amount is also indexed for inflation. So it hasn't gone up in a couple of years, but perhaps in a year or two it will jump up to 15 or maybe even 16. So it's called the it's called the annual gift tax exclusion, and that can be to, I think I said this, any individual per person per year. Okay, so spouses can combine their annual exclusion and get $28,000 to a child in 1 year without the requirement of filing a gift tax return. Okay, so a lot of times parents don't necessarily want to give their kids money, and they want them to learn to figure it out on their own. So instead of giving the money to the child directly, you can give it to a trust. So that child can benefit from the money eventually, but not necessarily right now. Okay? Then there's also life insurance trusts. So life insurance trusts, very simple concept. You can't be the trustee of the trust. You have to choose somebody else, all right? But the trust becomes the owner and the beneficiary of your life insurance policy. And if you transfer your life insurance policy to a trust, 3 years after that transfer, it can be out of your taxable estate if you follow the rules. Okay, so maybe not everybody knows, but life insurance that you are the owner of, the value of that policy is taxed in your estate. Okay, so if you have a $1 million policy out there, that's $1 million that's adding to the value of your estate and could be subject to pretty heavy tax. So we can easily remove the life insurance from your taxable estate. Yes?
Laura, that transfers, though, that $1 million policy transfers to the wife or the spouse, the surviving spouse. Is that correct?
Well, not
Tax-free.
if it's set up correctly. What you want to do is you want to have the trust be the beneficiary of the policy, and the trust will spell out that the spouse can get, there will be a continuing trust for the spouse. So that the continuing trust provides that it's not taxable in her estate, but she can access the money if she needs to with the trustee.
And without a trust, what happens?
Without a trust, the $1 million is taxed in the first spouse's estate. The surviving spouse is the beneficiary of the $1 million, and then it's taxed again. If she doesn't spend it, it's taxed again in the second spouse's estate. Absolutely. Good question. Gary.
Excuse me. Related to insurance, is there any tax on the inside buildup when it's transferred?
No. If you have an insurance, estate tax, insurance planning trust, your policy is tax-free. Income tax, estate tax, all around.
But
Okay?
when you transfer to the trust, it would be the cash value of the policy at the time of transfer you're making a gift to the trust. So you are required to file a gift tax return and report the transfer to the trust, and your unified estate and gift tax credit, which is currently the $5,450,000, is reduced by your lifetime gifts.
Right.
So if that policy was worth $200,000 at the time of death, your remaining exemption is reduced by the $200,000 gift.
Yeah, I should have explained that to you actually when I was back here on this slide. On the federal level, there is still a gift tax. On the New York level, there isn't. So you can gift to your heart's content and not report it to New York State. However, when you die, what New York does is they pull back the last 3 years worth of gifts that you've made. Okay, so they do want to see the last 3 years of gifts, and they add that back into your taxable estate. On the federal level, you have the $5,450,000. This is the estate and gift tax credit. So gifts made during your life, use that. They utilize part of that. And whatever's left is what you have on your death. So it's a unified system there. Okay? Anything else?
And that's why it's very important, the annual gift tax exclusions of the $14,000 per person per year, because those annual gift tax exclusions are not reducing the $5,450,000.
Let me see what slide I'm supposed to be on now. Okay. Okay, so advanced estate and tax planning. Well, we talked about gifting trusts. There are also trusts that can help you pass your business interests, okay? And if it's structured correctly, you retain control of your business while you can, and then eventually the kids can step in. There's also grantor retained annuity trusts where you're passing assets that have substantial value. You retain an income for a certain number of years, so you're making a gift to the trust of a valuable asset, but you're retaining an income interest or something, an interest in it for a number of years. What we've done is we've reduced the value of the gift because of your retained interest. So that can get kind of complicated, but there's charitable trusts and then there's trusts for your house, called qualified personal residence trust. The important part to note here is you really have to analyze the size of your estate and only make gifts if it really is going to save you both federal and New York estate tax. You don't always want to just worry about the New York estate tax because the New York estate tax is the highest rate of 16%. When you transfer assets by gift to your children, you can be transferring a capital gain to your children. So they're not going to pay estate tax on that asset, but there may be a built-in capital gain in that asset. So it's really important to sit down with your financial advisor or attorney and figure out, well, what are the tax ramifications? Do I need to make this transfer? Am I going to be shifting a capital gain burden, which the capital gains rate is higher than the New York estate tax rate right now?
And the reason for the shifting of the capital gain is that when a person dies, their beneficiaries receive a step-up basis in that property. So for example, if you bought your home and maybe your home was worth $50,000 at the time you bought it, it's now worth $2 million. When you die, your beneficiaries receive a step-up in basis to the $2 million, which means that they later sell that property. You calculate the capital gain based on the $2 million, not the $50,000 that the parent initially bought it for. So that's why it's very important to analyze both the income tax consequence, the capital gain consequence, and the estate tax consequence.
Yes. If you have the house in a trust and you want to sell it while you're alive, is there extra paperwork, legal work?
Is there extra paperwork?
Legal work, extra.
As is the trust, the only extra part here is who's involved in selling the house. So if you're the trustee of the revocable trust,
No, if you're the owner of the house, you put it in the trust.
oh, if you're the owner of the house to put it in the trust, yes, you have to transfer ownership of the property, and that has to be done by deed. Okay, and currently, I think the fee for recording the deed in Suffolk County is $390, and it goes up and up. It's $18 in Florida. Yes.
Do you pay the transfer taxes when you transfer to a revocable trust?
No, there are no transfer taxes. The transfer taxes are based on the value of the transfer. So you're transferring the property for no consideration. You're not taking anything back.
It's a gift, so it's not an actual sale. The transfer tax is on consideration, so there's no consideration for these types of gifts.
Okay, and if it's to a revocable trust, it's not a gift. Because it's basically to yourself. Yes.
Property outside the U.S.
Yes.
How is,
Good question.
yeah.
Good question. I mean, it really depends on the treaties that we have with the country. It is possible that the property can be titled into a trust, but I'm not, it really depends on the countries. Okay. Yes?
When the property goes into a trust, where is the benefit of mortgage interest deduction, property tax deduction on income taxes?
Good question. If it's a revocable trust,
Yes.
then all of the tax consequences of all of the assets that are in the revocable trust remain with the grantor, which is the person creating the trust. Okay? So if you created a revocable trust and transferred your house and some investment assets, everything in there, everything in the trust is taxed to you. Like, there's no change. Okay? If it's an irrevocable trust, there are so many different types of irrevocable trusts and so many different purposes that we'd have to talk about. One that's coming up is a Medicaid trust, and that actually keeps the tax consequences with the grantor as well. So if you create a Medicaid protection trust, then there's no change on your tax return. Everything's reported to you. Yes?
Another question on the New York State estate tax. I remember reading about what was referred to as the cliff in New York State.
Yes. Well, that was included in my That was included in my example as far as calculating what the tax is. The cliff is if your estate exceeds the $4,187,500, if it exceeds that by more than 5%, your taxes if you don't have a credit. Your estate is taxed as if you don't have that $4,187,500. So as soon as your estate goes over 5% of the credit, you're taxed as if you don't have credit.
So you're taxed on the entire amount?
The entire amount, yes. That's the cliff.
That's
Yes.
very significant.
Really significant.
Yes. Right.
Cliff.
Right, but that was included in my example there, so if you have a $6 million estate, it's $500,000 in New York tax.
Your example was under the 5%.
No, my first example had a $6 million estate, total combined estate, so that's over the 5%. Over 5%
I
of
thought it
4.
was over the 5%, over the 5.4. It's
Right, that by being 5% over the exemption amount means that you're taxed on the entire amount. They don't give you the benefit of that credit. So if you're exactly at the exemption level, there's no tax because you have that credit. But once you go over that 5%, now we're taxing you from $1 all the way up.
Most of the state taxes I've seen include pour over wills. So doesn't the pour over will then subject you to probate?
If it's necessary, yes. Typically, that's a good point, actually, something I was thinking about earlier, but if you do create a revocable trust, and Amory mentioned this, if you do create a revocable trust, sometimes not all of your assets, you forget about an asset. What I find often is clients who've had MetLife insurance and MetLife demutualized, they forgot that they own MetLife stock. They were actually issued stock certificates years ago. So you can't just rely on a revocable trust. You always have to back it up with a will. And what we usually do is something called a pour-over will. We have a will that says, well, just in case I left anything out of my revocable trust, if I die, I give that to my revocable trust. That's what your will typically, that's the pour-over will. It just pours it into the revocable trust. So you want to make sure you always have a will in case you don't retitle all of your assets correctly. Okay?
So Laura had talked about the impact of trust or the importance of trust in the context of estate tax planning. Trusts are also important for long-term care planning purposes. So what is long-term care? That's care for assistance with daily activities, such as bathing, toileting, transferring, getting up, moving out of from the chair or out of the bed. Feeding, grooming, showering, and walking. So if you need assistance with any of these activities of daily living, then you might require assistance at home or in a nursing home. So how do you pay for long-term care? There's various options. There's long-term care insurance, but you have to look at the cost of the premiums and whether or not that is affordable for you. There's other factors that go into whether or not long-term care insurance is even viable for you. It depends on your age and what type of health conditions that you have. Out of pocket, so you can pay for your long-term care privately. So for nursing homes here on Long Island, we're talking about somewhere between $14,000 to $15,000 a month to pay privately. And for home care, you're probably talking maybe about $7,000 to $8,000 if you needed round-the-clock coverage, or even more. So Medicare. So some people think that Medicare provides some level of assistance with long-term care. They do, but only it's very limited. You have to have been in the hospital for a 3-day hospital stay and then be discharged to a skilled facility for rehab purposes. If that's done, then you are able to receive 100 days of skilled nursing care. The problem with that is that at any point, after the first 20 days are paid in full, and then from 21 to 100, there's a copay. rate, but the nursing home or Medicare could cut that off sooner. So if you level off and are no longer being considered being rehabilitated, then the care stops, the coverage stops at that point in time. And now if you're still in the nursing home, you have to pay privately or apply for Medicaid, which is the final option. So Medicaid is a needs-based test. What that means is there's various eligibility requirements in order to qualify for Medicaid. So in order to understand how Medicaid works in the context of nursing home or in home care, we put together information on assets and income eligibility requirements. So in order to receive nursing home Medicaid, you can only have $14,850 in your individual name. Besides that, your home is exempt, provided that the equity value in your home is less than $828,000. You're also entitled to have a prepaid burial fund, which you can set up ahead of time with a funeral home. Term life insurance, because there's no cash value to a term policy, you're entitled to keep the term life insurance. And then household effects and a vehicle is also exempt.
Just a note on the home. This is for the Medicaid applicant. If you look at the top there, this is the eligibility for the Medicaid applicant. If the applicant dies owning their home and they've used Medicaid, Medicaid will put a lien on the home to recover their benefits, recover what they've expended for that person. So it's exempt, but it's only exempt while you're alive. Okay?
Right, and then the income requirements for nursing home Medicaid, all the person is entitled to keep is $50 of a personal needs allowance. On top of that, the cost of any secondary health insurance premiums are also paid out of your income. So typically, if someone has Medicare and a secondary insurance, the premium is allowed to be paid out of your monthly income. The net amount, which is called the net available monthly income, routinely it's called NAMI, that then is contributed to the nursing home. So if you have $3,000 of monthly income, and let's say your secondary health insurance policy is $250, it means the difference is then submitted to the nursing home in order to receive Medicaid benefits. For home care, so it has the same asset requirements, so the $14,850 in assets, the home again with the equity limit, and the various other items. The difference for home care is that you are entitled to keep $825 of monthly income, which for any person living on Long Island, $825 does not go far. There are ways to preserve the balance of your income. It's a little complicated, but you would be paying it over to a pooled income trust. And that pooled income trust is handled, and it's with a not-for-profit organization. So on a monthly basis, your excess income goes to this not-for-profit organization who holds it in an account for you, and on a monthly basis, you submit your monthly bills. So if you have your electric bill, you're able to submit that to them, and they'll pay out of your account those items. The downside with the pooled income trust fund is that upon your death, whatever remains in that account stays with the not-for-profit organization for their general purposes. But it is a way to keep the person at home and to be able to utilize the rest of the income. Now, the two slides were for a single person. So if there is a community spouse or a spouse living at home, there are some benefits for Medicaid. So in that situation, the community spouse can keep the home, and there's no equity limit for that. So the home could be worth $2 million, and you're not subject to the prior equity limit. And assets between roughly $75,000 to $120,000, which again is not a lot for the community spouse to live on. They are entitled to income of $2,980.50 a month. But the real benefit here is that New York allows a spousal refusal. What that means is the spouse can sign a statement saying the assets in my name are not to be used to pay for the care and the support of the spouse in the nursing home or the one at home needing care. Medicaid has to approve that person based on just their individual assets. They can't look at the spouse's assets. So that's a great feature that we currently have. Hopefully it will continue that way. I know that every April when Albany is trying to figure out the state budget, a lot of times that's on the chopping block, but thankfully it hasn't been repealed. But one thing to point out regarding the spousal refusal is that the Medicaid agency has a right to sue the spouse for support. But that is sporadic in Suffolk County. Other counties do pursue it, but here in Suffolk County it's been very random with them coming after the spouse. Yes?
The equity portion of this house, $828,000.
Right.
Would that be the total value of the house or half of it?
Well, it depends on how the title is to the property. So if you own the property with the spouse, again, there's no equity limit, so you're fine. But let's say the property is owned with a child. It depends on how the title is on the deed, what percentage. If it's 50-50, they will just look at the value that the applicant has.
What if it's owned by one?
If it's only owned by one of the spouses, the idea is you want it to be in the community spouse's name, the one not applying for Medicaid, and then that spouse could sign that spousal refusal form. And you would be protected there.
So you would transfer the house before a Medicaid application.
And we're going to get into this about transfers in a minute. So for home care and nursing home, yes?
Just one, if the house is jointly owned, spouse, parents, and a child, or a child, more than one child, can the child also have that spousal reference?
No, but the child, so the question, if I understand correctly, you have title in the property between the parents and a child, right? And you asked whether or not the child can execute that refusal form. There's no refusal for the child. The assets of the child are their own assets. There's no obligation of support by a child, so Medicaid can't look at the assets of the child. Yes?
How are assets viewed if held in an LLC?
Who is the member of the LLC? So if the member of the LLC is the parent that's applying for Medicaid, that's an asset of theirs that if they will not qualify for Medicaid.
And the value, essentially the value of the assets of the LLC or the LLC itself. And that value counts towards the $14,850.
So one important aspect of Medicaid planning is the look-back period. So for home care, there is no look-back period. What that means is I could transfer assets today, and next month I could qualify for home care, provided I meet all the other requirements up down to the $14,850. And for nursing home care, there is a 5-year look-back period. What that means is if I transfer assets today, I can't qualify for Medicaid until 5 years from the transfer of those assets.
One important thing to note is transfers of assets between spouses is okay. Okay, so the look-back period, what the Department of Social Services is doing is saying, did you transfer assets to make yourself Medicaid eligible? Because if so, we're going to penalize you. All right. So, but you're allowed to transfer assets to a spouse without getting penalized. Okay. So that goes back to the spousal refusal. So if there were emergency planning that needed to be done and the spouse needed to go into a nursing home, we can transfer all the assets to the well spouse and have the ill spouse apply. And the well spouse signs the spousal refusal, which says, I am submitting all of my information because I'm required to. Both spouses have to submit the information. And even though I have a duty to support my husband or wife in paying for their medical expenses, I refuse to use my assets to do that at this time. Okay?
Oh, all right, well, we're going into protecting assets.
Right. So how do you protect assets from long-term care expenses? Again, I touched on the long-term care insurance. Again, only if that's affordable for you, because you will be paying annual premiums, and those premiums do increase yearly. Yeah, the premium is not a guaranteed premium. So it is a great option if it's affordable and you can qualify. Outright transfers of assets to children. Typically, this is not the best option, transferring assets outright to a child. The assets then are no longer protected. If that child has any creditor issues, those assets can be reached by their creditor. What if the child predeceases? What happens to those assets at that point in time? Or divorce, you don't want to have any issues where that the spouse is trying to make a claim to those property. So that's really not a preferred option. Transfers of assets to an irrevocable income-only trust is the best alternative. And what that trust provides is for the grantor retaining the right to income and the right to live in any property owned by the trust, but no right to the principal. That's why it's protected for Medicaid purposes, because you can't take the assets back out of the trust. So again, after a 5-year period, the look-back period, once the 5 years expires, those assets to this income-only trust would be protected for Medicaid purposes and could not be reached by Medicaid.
Okay, so this type of trust is created in such a way, and we mentioned there's so many different types of trust, but this type of trust is created in such a way that it's called a grantor trust. Because the grantor it's creating the trust, the grantor is putting their assets in the trust, but the grantor is not the trustee and not the beneficiary other than income. It has certain qualities in it that make sure that whatever tax consequences happen in that trust remain with the parent, the person creating the trust. Okay? So the grantor, it's a grantor trust, all tax consequences stay with the grantor. Okay?
That also includes real property exemptions, so the STAR exemption or any veterans exemption that you might have on your residence. With this type of trust, you would still qualify for those exemptions as well.
And Amory mentioned that this trust has to provide that the grantor is not allowed to get principal back out of the trust. Okay. But we also mentioned earlier that if something happened and the grantor needed those assets back, even though it's an irrevocable trust, New York State allows us to, all the beneficiaries, the grantor, everybody gets together and can actually get that trust revoked. So it says that it's irrevocable, but there is a mechanism to revoke it. It also says that the grantor cannot get assets out of the trust, but the kids can. So if mom puts $200,000 into one of these trusts, that planning is really, the only reason why mom is doing this is so that those kids will inherit that one day. But let's say mom doesn't need care and wants to go on a cruise and needs $8,000 out of the trust. So $8,000, she says, kids, give me $8,000 back. Well, kids are going to say, no, mom, the trust doesn't allow us to do that. But the trust does allow the assets to be distributed to one of the children. So one child would make a distribution to the other child, and then the other child would give it back to mom. It's kind of a backdoor way.
But if there's one child, that's it.
Well, if there's one child, we would need to find who that successor trustee is on your documents. I mean, you're always going to try to layer the trustees. We would have that successor trustee step in and make the distribution to the child. Yes?
Can a property that has a mortgage on it be placed in a trust?
Yes. The short answer is yes. There's a federal law. Yeah.
Correct.
You want to go?
The mortgage documents have an acceleration clause. What that means is if you transfer the property out of your name, the mortgage would be due in full, but the lender has the right to call the mortgage in. There is a federal law that spells out exceptions to that rule, and when a trust, when you create a trust and you're the primary beneficiary of that trust, that will qualify for that exemption. So since you have the right to live in the property for your lifetime, it should qualify for that exception.
What about if there's a reverse mortgage on
Same thing. Same thing. The reverse mortgage actually raises some other issues, because if you took a reverse mortgage and you took a lump sum, it should be fine. But if you have a regular stream of income from the reverse mortgage, that could be deemed a return of principal to you. That violates the terms of the trust. So Medicaid could potentially try to say you're getting principal from the trust in violation of the terms of the trust and expose all of the trust assets. So reverse mortgages with the trust could be a little tricky.
And to answer some of your questions, it is possible now, but years ago it wasn't possible. If you put the house into an irrevocable trust, for the grantor to turn around and say, well, I need to draw equity on my house, can I get a reverse mortgage? There are lenders now that will lend if your house is in an irrevocable trust. One thing I wanted to point out about the way that the trust should be structured, and I know not all attorneys do draft it this way, but it should be structured so that the grantor, the parent, I'm just going to call them the parent always retains the right to change who the beneficiaries are. Okay? So you set it up and you name who the beneficiaries are, but there's a mechanism where you can change the beneficiaries. So if your son doesn't do what you want him to do, you can say, you know what, sweetie, I'm going to take you out. You can write him out. So that's kind of indirectly, even though you're losing a lot of control over the day-to-day management of the assets, indirectly it kind of gives you control over everybody.
And then another way to protect assets for long-term care costs are emergency planning. So you didn't create an irrevocable trust 5 years ago, and now all of a sudden you need nursing home care. What can be done? Well, there is emergency planning that can occur. It's very complicated, but roughly you could save half of your assets through the use of a gift and a promissory note. I think it's more complicated than we want to go into today, but it is possible that if you did no planning for long-term care, you are still able to save roughly half of your assets.
All right, so we're out of time. We're actually over out of time, but because today we were talking about trusts and all the different types of planning with trusts, we put in the back here some things that you have to pay attention to when you're selecting your trustees. You have to know what their responsibilities are going to be, and some things to think about when you're selecting trustees. So you can read that on your own. All right?
What's the expense to set up this on the grantor trust to protect assets for Medicaid purposes?
Long-term care, yes, an irrevocable income only trust. It typically runs about $5,000. Okay, but that's more of assessing your whole situation. It's not just, here's a trust, you put in what you want. We help you with everything. We help you fund the trust, we help you make sure all of your other documents are in place, and it's really just a very comprehensive estate plan. Any other questions? Yes?
I have a question on the Medicaid application with income. Okay.
Yes.
What if you have Social Security, a large pension, etc., and you cannot, is there any way of meeting that kind of monthly income when you have a great deal of monthly income?
Well, we actually have to do an assessment at the time of your income compared to the expenses. So if you have monthly expenses that can consume all of that income, then it's not a problem. And it's home care, it's not a problem. We can put the assets into the income into the community pool trust and then direct the trustee what bills to pay. Okay? But if you don't have expenses that will consume that monthly income, we have to analyze, does it make sense for you to just pay for the care individually? Or or does it make sense to apply for Medicaid and jump through hoops and lose some income? Okay? Yes.
What is the charge to set up a simple revocable trust or irrevocable?
It varies, because again, the purpose of it. So if it's a revocable trust, along with, the ancillary documents, your pour-over will, your healthcare proxy, your living will, and power of attorney, you're probably talking somewhere in the neighborhood of about $3,000 to $3,500 for that. The irrevocable trust, because that really, you're doing that for more of a purpose, a tax savings or for long-term care planning, that gets more expensive.
It's less than 1 year's worth of premiums for long-term care insurance. All right. All right. Well, time is up, but I will stay to answer questions. That's fine. But we do have, if you're interested in staying in touch with us, and please sign and give us your email address, and let us know who you are so we can send you emails on what's going on with the laws and the changes. Okay.
Okay.
All right, so we're going to close it for now, but if you want to stick around, we'll stick around. Okay? Thank you.
All right, thank you. Absolutely, Ken. Please feel free to stay. These folks are happy to stay and answer questions. And thank you all for being here. Thank you both for coming. We have a library pack for each of you.
Thank you.
And let us know topics that you are interested in with regard to estates and planning, and we'll try to comply. Thanks again.